Are you getting a lot of calls and a lot of emails and a lot of stuff? I'm getting a lot. A lot. I've got several letters that today.
Well, good morning. Thank you for coming today. This is the second meeting of the House Study Committee on Shared Parenting, and I'd like to thank you for all showing up today. This has been an extremely special occasion for me already today. When my car died in the Peachtree Industrial Boulevard, right in the middle of the road, and fortunately I was able to get it off to the median. So for the last this is a really tale of blessing here. I mean, this is great because about an hour ago, I was standing there wondering how I was going to make it here for this session today. But things all worked out. AAA's got the car, and they're off to the garage. It's getting hospitalization now, and pretty soon we're going to car Medicare. Yeah, right. And so that's all working pretty well today. Today I'm going to be, I have to leave at 1:45 today, so it'll be a little bit abbreviated. This is supposed to go from 10 to 1, but we're going to pick up a little bit on the front end because I'm not going to make the same comments that we made last time when we started off this meeting in terms of what we're here about, because I think you probably had a chance to look at it on the web already. We'll go to 1:45. And at that point in time, I've got to leave. I am on honorary pallbearer for one of the greatest World War II heroes that I know of, and a man has affected my life greatly, Colonel John Fain, who at 96 passed away last Friday. What a great individual. Served on General Douglas MacArthur's staff in the World War II, and just an incredible guy. So today's a great day for him. And I'll be leaving a little bit early to share that experience with the family. Let me just introduce the members of the study committee. Starting here on my left is the Honorable Earl Earhart, who is the chairman of the House Rules Committee. And right beside me is Keith Williams. Keith is from House Research and serves as an aide to Representative Earhart. To my right is Chairman Judy Manning, chairman of the Children and Youth Committee, the House of Representatives. And to her right is Edward Lindsay, Representative Edward Lindsay. Representative Lindsay is vice chairman of the House Judiciary Committee. And probably about 10 minutes from now, there'll be another individual join us who's running also a little bit late this morning. No car trouble, but several other issues that came up in his life this morning. And that's Representative Mark Butler, who is Vice Chairman of the State Institution Properties Committee. We're here today to listen to what you have to say and to try to understand what the issues you want to talk to us about are. You need to know that all this is being recorded on these cameras around about here and will be available on the web for your review, as was the first session. Do we know whether that's up yet or not? It's been put up today. The first session, which occurred Monday of last week, is being put up on the web today. It takes a little bit of time to get it done, but it'll be up today. I told them to take their time in doing it because I wanted them to edit it out. Every time I duck my head and I reflect heavily into the camera off my head, I don't want that all edited out. So that'll be available. There's one other meeting that will occur on the 26th of October. And that'll be a meeting kind of to pick up all the loose ends type of thing in terms of people who have not had a chance to testify or and to start the summarization of where we are. But that's it. Are there any other comments from any of the members of the committee here today? Anybody have anything they want to say? I thought we had a great time a week ago in terms of gaining perspective on the issue of shared parenting, and I know we'll have the same experience today based upon the witness list that's already signed up. We have 1, 2, 3. How many are there on here? 10. Okay. If we went and took maybe a 10-minute break around 11, 11:30, 11:15, 11:15. 11:15 would be good. Okay, Judy, you're the one to keep me on schedule there.
Only old person here.
Well, I know.
We need a break.
Have a break today.
You're going to need to feed.
Thank you. I appreciate that, Mr. Chairman. We have 10 people on the list today. If there are any others who come in who need to testify, we'll try to fit you in after that. We'd like you to hold your remarks today to about 10 minutes and leave some time for questions if possible. Also,
Do we have a list of the sign-ups of who all's here?
we do not have a list. No, we've got a list of the people who've signed up to give testimony. You think that'd be a good idea?
Well, just like, I know, I see some faces. though,
Okay.
but
All
not all.
right. You want to start?
If you don't mind. You don't have to.
If you would care to sign up, Chairman Manning would like to know who is present in the audience today, and that would be fine to do. If you just put down your name and who you represent, telephone number, that would be great. So if we could get started now, is there anything else that we need to do as a committee before we get started? I think we're fine. Oh, I'm sorry, I didn't introduce these are great ladies at the end of the table here. This is Jill Travis. Jill Travis is from Legislative Council, and she works with the House Judiciary Committee, and I appreciate your being here today. I'm sorry, Mary Lewis. Mary, you're so new. You got a mental block there, but thank you for coming with us today. And you're also an attorney, right? Is that correct? Soon to be an attorney, as is Keith, soon to be an attorney. So, all right. Well, look, let's run through the witness list. If you have a desire, the other thing I want to mention was that as these sessions go, and I've been exposed to a number of them over the time I've been here. Many times there are anecdotal forms of information which are important. If you have any specific data, study data or things like that you'd like us to hear, we'd like to hear about that also. You can make a submission in writing to us, either by email or and you can find us all on the web, and I think you already know how to do that. Or you can make a submission to us in writing, and we'll consider that as your testimony as we go through summarizing the ideas that are put forward here today. Okay, well, let's get started then. We have Ms. Nancy Megara, and Ms. Nancy Megara is from the Cliff Valley Psychological Associates. And welcome, Ms. Megara. Thank you for coming down here today and testifying for us.
Thank you. I was pleased to be able to come today. I had a flat tire yesterday on my way home from work, so I know what you're going through. I'm a psychologist. I am representing psychologists in Georgia here today. I'm past president of the Georgia Psychological Association, and I'm currently active in the association in children's legislative issues and public education and ethics committee. I am talking about a variety of issues involving psychological components to the shared custody issue. I was asked to speak about several different things, so I'll try to go over those. I put some of the highlights and the research in a handout for you. The first thing that I wanted to mention was the issue of the best interest standard in Georgia. It is the most commonly used standard by states because it is a gender-neutral standard which allows mothers and fathers to have an equal footing. The advantage is that it makes the determination of custody a child-centered decision as opposed to an adult-centered one. Obviously, divorce and custody issues are psychologically difficult issues for everyone, and the most appropriate thing seems to be is to make those decisions that are child-friendly and conducive to psychological stability for everybody, but specifically for the child. The best interest standard takes into account the developmental needs of the child, problems that highly conflicted families have, issues like domestic violence, substance abuse, psychological problems of the parents, which as a custody evaluator I end up spending a lot of time trying to evaluate. And in the end, hopefully a child-centered decision is made. There's lots of research on this. Most of the research uses the term joint custody and not shared parenting, so if I use that term, I'm not trying to be pejorative. That's just what the research calls it. And what the research tends to show is that it can be extremely beneficial to families. The current theme in research is that when families choose shared parenting, it's usually very successful. When it's mandated on families who are not choosing it, who are highly conflicted, it has sometimes disastrous results. Frequently, the conflict increases after the award of shared parenting or joint custody. There's many research studies that talk about that. And many of the research studies also only include families who have chosen joint custody. So it's a little misleading if you try to figure out the results of that to not know whether this was a mandated shared parenting or a chosen shared parenting. So the target population of the study is important. There's also different studies that show that domestic violence occurs in a huge number of the contested custody cases we see. One study found up to 40 to 50% of families in that situation. There was just a study done in Canada where families that had high conflict were mandated joint custody in an attempt, the courts thought that might decrease the animosity between the families. They actually found an increase. That was just done this year. It was also found that parents who are mandated shared parenting relitigate as often as parents who are given sole custody. So it's a variety of problems with the research if you have parents who are mandated it and are not asking for or choosing shared parenting. Another issue is the term shared parenting. In the research, it actually can mean anywhere from 30% to 50% of time sharing. So it's not necessarily a 50-50 split. It could be a 30-70 split, which many people, if they heard that, they would think that was a sole custody situation. But 30% of the time with one parent is actually defined as shared parenting in most of the research. The other thing I have found is that, and the studies back up, is that most families are able to settle this by themselves. They do not go through a extended litigation. They do not have custody evaluators and guardian ad litems. It's only anywhere from the top 1% to the top 10% of high conflict families reach that point. But when it does reach that point, it takes a lot of evaluation to try to figure out what's going on and what might be best for the family. The importance of the forensic psychologist I was asked to mention. There are not enough custody evaluators in the state. It's very difficult work. But I think judges tell us all the time that they're really glad that it's being done because there's no way that they can adequately evaluate the vast numbers of problems that we see in some high conflict families in a jury or non-jury case, that it's a multitude of things are examined, everything from past history of caretaking of the child, stability of the parent, any substance abuse, domestic violence, child abuse, how fixed the parent is in their opinion of the other parent, what access they're going to give the other parent to the child. So all of those issues are things that are examined by the forensic psychologist. There's also a lot of issues about high conflict families, and we see the most high conflict families by the time they need an evaluation. And what we found is that the more children are exposed to conflict, the more disturbed you find in terms of adjustment. And that's found in many studies. I included a bibliography. It's just skimming the surface. I can give you more references if you want them. But many studies, especially from recent studies, show that in highly conflicted families, the more the child is exposed to conflict, which generally occurs at transitions, the more disturbances the children are experiencing. Another thing I was asked to mention was whether the American Psychological Association has done research on this or whether they have a stance on this opinion. And actually, they issued a press release in 2002, and that press release is titled, "Children Likely to be Better Adjusted in Joint versus Sole Custody Arrangements in Most Cases, According to Review of Research." Okay, that sounds very cut and dried, and it's important to look into what that press release was about. APA did not do the research. They reported on a study that was done in 2002 by Bauserman, and I put that reference for you. But in the study that Bauserman did, joint custody was defined as either shared physical custody or shared legal custody. Obviously, that's a huge difference. You can have shared legal custody where both parents have input into every aspect of the child's life, but it doesn't say anything about what the physical plan is. So that's how they define joint custody. And what Bauserman actually stated in that, and this is a quote, "Children do not actually need to be in a joint physical custody to show better adjustment, but just need to spend substantial time with both parents, especially with their fathers." Goes on to say, "It is important to recognize that the results do not support joint custody in all situations. When one parent is abusive or neglectful, there can be serious mental health problems for the child." So that's, I think that's been very confusing to a lot of people when they see that press release or they see the Bauserman study, to realize, A, that it was looking at joint legal or joint physical custody, and B, that if it was not an appropriate situation for shared custody, that there were detrimental effects to the child. I was also asked to mention, when is joint custody or shared parenting successful versus not successful? Lots of research on that. They have found that to be successful, you have to have the parents appreciate the bond that the child has with each of the parent, despite any feelings they have about the failed marriage. They have to have a certain psychological maturity so they can step back and maintain some objectivity, at least relating to the child. They have to be able to empathize with the point of view of the child and the other parent. They have to be able to shift their relationship from a spouse relationship to a co-parent relationship. They have to establish new boundaries about that role, and they generally have to have some good self-esteem and flexibility. Joint custody has been shown by research to be not successful when the parents had intense continuing hostility or conflict. They had overwhelming anger and the need to punish the spouse. They had a history of physical or substance abuse. They had a belief that the other parent was a bad parent. And they had difficulty separating their own needs and feelings from the child. So those are kind of what the research pulls out as pluses and minuses about shared parenting. It's obviously not a one case fits all. The last issue I was asked to mention was the child's right to choose in terms of custody arrangements and what the psychological research showed about that. It was interesting. There's a 2006 review that two attorneys here in Georgia did. They reviewed the states and to see what the different statutes were. And there were only 9 states other than Georgia that had a specific age referenced in their law about the child's election of custodian. Most of the states say that the child's preference should be considered or can be considered, but they still apply the best interest statute. Georgia was actually the only state which leaves the court no discretion for a child of 14. And the only way the court can deny a child's election is if parental unfitness is found. The psychological research on that that's important is the new data that's come out about adolescent brain development. Anyone that's been an adolescent or has an adolescent, this isn't a real surprise, but we now have brain mapping to prove that the frontal part of the brain is the last to develop. That includes impulse control and decision making. So we found that actually starts getting more developed in late adolescence, early 20s. So the later in adolescence you are, the more likely you are to not make an impulsive decision, to weigh out the costs and minuses, and to not be swayed by impulsive decisions or promises from a parent. So obviously the psychological research would say that a 14-year-old, there's 2 problems with a young adolescent put in an election position. One is that they don't have the brain maturity to make those kinds of decisions. Secondly, the emotional cost. And I see this every day of children being put in that position to choose between their parents. Children feel very torn. They love both their parents, even in abusive situations, and they don't want to be put in that position. So my conclusion is that if there's a divorce in a family, children absolutely benefit from a relationship with both parents. That's not in doubt. But that whatever pattern that access to parents is going to be needs to be drawn by a look at the children's developmental needs, and the plan needs to be flexible and looked at on a case-by-case basis to see the best way to do that. There was a large study in California in 1992 where they did award joint custody in cases where families were asking for sole custody. The court mandated shared parenting. And they found that it did not improve the relationship between the parents. They were not able to co-parent better. In fact, it caused higher conflict and more problems for the children. So that's our main concern. Is I work with these families all the time. The children are in crisis. They're very difficult situations to look at in terms of parent psychopathology and other issues. And we don't think a case-by-case basis is the wrong approach. We think it needs to be an individualized approach for each family.
Well, thank you for your testimony. Questions from the committee? Start on the right-hand side. Mr. Lindsay.
Dr. McGarrett, thank you very much for coming. Let me also say that as a father of 3 children between the ages of 13 and 15, I have no trouble believing the last thing to be developed.
Edward, move the microphone a bit closer to you.
Thank you. I thought it might be helpful to the rest of the committee who are not lawyers, who do not practice in domestic courts, for you to sort of explain exactly when it comes to being a custody evaluator, when they bring in a psychologist, what exactly do you do?
Okay. Usually we have a court order. Sometimes attorneys will agree and do a consent order, but usually we have a court order where families cannot agree. These families usually cannot agree on whether this is Tuesday or Wednesday. They are in conflict on just about everything involving custody. And so the judge orders an evaluator, and usually one name is decided upon, or the judge appoints somebody. And we see every member of the family for intensive amount of interviews. We do psychological testing. We do a test battery. We also, if it's a modification, we will see if parents have remarried, if there's other children involved. We'll see each of those people. We'll try to get an understanding of what the issues are. We will do observations. Some people do home visits. I do observations through a one-way mirror where the children are playing in a playroom with the parent, see what that interaction is like, try to get a slice of their life. We also spent a lot of time looking at documents, court documents, other kinds of documents that parents may want us to review. And then we do a great many consultations. We talk to the school teachers. We talk to different therapists that may have been involved with the family, references that might be important that have witnessed different things, specifically firsthand witnesses. And then we try to put all that together. Many of these cases also have a guardian ad litem appointed by the court, and if that's true, we work together and we try to reach some kind of consensus about what's best for the child. And at the end of that, the judges in Georgia, not all states do this, but in Georgia, the judges want specific recommendations. And so at the end of our evaluation, we try to give very specific ideas of what might be best, what might reduce conflict, what might be most healthy for the child. And then it goes to the attorneys and the judge. Does that answer your question?
Other questions from the committee?
Can I follow up with that one?
Sure. Chairman Manning?
Doctor, do you also include any battery of health screenings at all?
Oh, sure.
Of the child? Or you look at their physical?
Right. We look at medical records. It's very important to look at adult records also. I'm doing an evaluation right now where there's alleged drug or alcohol abuse on both parties, and we will sometimes do random sampling of testing during the evaluation to try to get some information about whether a parent is abusing something. So we look at medical records and educational records both.
One more. Do you also look at whether or not a child has had some sort of medical or physical defect along the way because of the divorce? In other words, if the child herself or himself has a conflict issue with one or more parents?
Definitely.
And the other thing I'd like to know about is do you consider at all income in your evaluation as to who is better able to I guess, for lack of a better word, care for the child, even though that's not the proper word. I guess
Right.
afford, and afford's not a good word either. Whether you have two income parents or whether you have one single income parent, and whether how the parents' schedules work and all that kind of stuff.
We look at that. We do not get as detailed in terms of the finances as the court would get. But, for example, let's say part of our assessment is that we find a child has a special need and they need to go to a special tutor or a special school, and one parent either financially is supporting that or just by agreement thinks that's a good idea for the child, and the other parent maybe thinks my child's fine, I don't believe these test results, we don't need to pay for the tutor. That would definitely come into play. In addition to how often are the parents going to allow or facilitate time with the other parent? Are they going to be able to buy that plane ticket? So it gets into some of the finances that way, but we don't look at details about child support or things like that. We leave that to the court.
Representative Earhart.
Thank you, Dr. for coming and testifying. I'm trying to get an idea. The idea of custody evaluation, you certainly go into a great deal of research on the families. What's the average cost of such an evaluation? It would seem to me, as good as it is, can most Georgia families afford a custody evaluator?
It's a good question. That's a real problem, is to try to do this amount of work and do it ethically and do it thoroughly and do it cheaply. It just doesn't work. In fact, there are some people that have gotten in trouble with the ethics committee because they've said, oh, I can do that in a week, and the attorneys are thrilled and the parents are thrilled, but they don't do it thoroughly. One issue is that there are very few families in terms of the percentages that actually get to this point. Like I said, the research shows that about 90% of families don't need this. They figure it out, they settle, they can come to some kind of terms of what would be best. So it's not a very large number of families that go this route. There are some families that definitely need this, that can't afford it. Fulton County, for example, has experimented with having an in-house court-affiliated psychologist. Of course, she immediately was swamped with referrals. So it's a hard problem to try to get a handle on.
Thank you.
Okay. One other question that I have, this, going back to your comment about 10% are high conflict families, I'm not sure I understood exactly how you were using that number.
Well, that's what the research has shown, and that's actually what we find in
10%
Georgia.
of what?
Of divorcing families.
Okay.
Families that are going...
Are high conflict.
10%, right. Well, there are a lot of families less than that that have some conflict, but they don't go all the way to a custody evaluation. Between themselves and their attorneys, they're able to work out some kind of settlement.
Okay, so I'm getting the idea, I think. So the high conflict families are the ones that go to the custody evaluation type
Right.
situation.
Right.
All right. Okay. Where's the guardian ad litem and the custody evaluator?
How do they work together?
Well, stop and start. I mean,
Well, the guardian ad litem obviously is usually an attorney, not a psychologist, and so they don't do any of the testing. They frequently don't do as many of the in-depth interviews. They will see the child and the family together. They'll do home visits frequently. They will sometimes do school visits, which is hard for us to get out of the office to do. And the main thing I find very helpful with these families is when there's a guardian ad litem and an evaluator, you have two heads working. And
Right.
so you can have double the amount of input into what each person sees with the child and with the different parent relationships. So it's a different role, but we work very closely together to try to come up with, ideally, some common recommendations. That seems to be most helpful to the court.
when you're addressing the custody evaluation and in the greater range of all divorces that are contested and come to the court, what I'm looking for is any kind of success information that says in the 10% high conflict family situations where there is, well, what percentage of those, do we have any information on how many of those go to a mutual shared parenting agreement or a mandated shared parenting agreement? And of them, which ones are successful, which ones not?
Actually, we're doing a research study now. There are about 8 psychologists in Atlanta that are trying to do a research project to figure out, we're all giving the same measures. We're trying to get the results of the measures, putting into the computer our recommendations, and then what the court ends up doing or what the parties end up settling. There isn't any research that I know of, at least not in Georgia, about that. I can tell you that anecdotally, of the evaluations I do, most of them settle after the report is issued. The parties, I think, work with their attorneys to try to see what they need to shift a little bit, but that basically this has been a thorough evaluation, and they try to work on that. So of those, not very many go on to a full-blown custody trial. Some do, but most of them seem to use that as a settlement tool.
Okay.
And I would say of those, there are not many who end up with a shared parenting if you're thinking 50-50. Because, like I said, these are high conflict parents. They're parents with psychological problems. They don't see the benefit frequently in the child being with the other parent. They are not able to. I have parents who have police officers with them during transitions. Those parents are not able to do that without conflict that hurts the child. So what we try to do is some type of arrangement where the child isn't exposed to that, either have all the transitions happen at school or in some other situation. And we, though, frequently will have joint legal custody. We will frequently suggest a joint legal, because we think both parents need to be involved in decision-making. Sometimes we'll have to put a way for that to work. If you have 2 parents who can't agree and you say you're going to make joint decisions on everything, how are you going to make that happen? So we have to come up with creative ways of having a therapist designated as somebody that they will go to on major decisions to talk it out, or sometimes there'll be an arbitration system that's set up by the court. But joint legal custody is suggested frequently. Joint physical custody in terms of 50-50 isn't very often, but frequently it might be 40-60. We just try to work on the transitions.
Okay. Let me just keep on this for just another second, and we'll let you go. Of all when you talk about a shared parenting agreement, there are obviously a couple different types. I mean, the ones that are choosing shared parenting, they never see this statistic you're
Right.
talking about, right? Because they work out a shared parenting plan and they agree that, you know, so on and so forth, it's going to have so much time and when and so on and so forth. Are you saying that only in 10%, up to 10% of the divorce situations where there's a custody trial, basically, that there's an issue with mandating any kind of a shared parenting agreement? Would that be your conclusion or not?
I'm not sure.
Okay, let me try and rephrase that. I'm trying to get at this. What I'm trying to do is to get to the numbers a little bit better in terms of understanding the dimension of the issue. You know, it's difficult for me to probably phrase the question that way. And what I'm going to do is take my leave and get back to you when I can and rephrase that better. This is the second time this happened. This happened the first time we went around to it. I couldn't remember exactly how to get at it, so we passed it off. I'll give you a call. And,
Okay, well,
we'll
I mean,
talk
I
about
think
it.
one thing, there's not, the 10% isn't a magic number. It's not saying that there's only high conflict in 10% of the families. It's saying that they usually don't end up in a contested custody battle with an evaluator, because that is only reserved for the families that really cannot work it out. So there may be conflict in other families more than that, but they usually are able to somehow work it out. They may go to court, they may not. But in the families where we see significant parent pathology, which is usually the issue in the families that come for a custody evaluation, that's probably the top 10% of cases filed in Georgia.
Thank you for your testimony. We appreciate it. I'm sorry.
This may help with your question. Perhaps Dr. Guerra could simply give us a copy of the Bauserman report that you
Sure.
at the American Psychological Association reference, as well as the study regarding the 14-year-olds.
Okay.
My wife and I in particular would like to see that.
You want me to get that study to,
All right, we need to move on. Thank you.
I'm going to be really quick. Do you happen to know, of the kids that you test, do you ever see a problem where both parents are the child should not be placed with both parents? And if that recommendation happens, what do you do? Do you recommend that the state take custody, or I mean, how often does this happen? I mean, divorce is bad,
Right.
but there could be two bad apples in the barrel.
frequently we find so many problems with both parents that you find yourself in a quandary. The question then becomes, can either parent safely and effectively parent the children? I'm sure in the 20-plus years I've done this, I've had that happen where both parents really, truly were unfit, and we recommended a family member possibly care for the child. Sometimes we have grandparents who are the main caretakers at the time of the evaluation. But in general, we try to come up with enough guidance so that the parents can keep parenting, whether it's extensive therapy help. Sometimes there will be a guardian ad litem that keeps working with the family, or a court-appointed person that keeps working with the family, so there's some safeguard. Most of the time that happens, but there have been a case here and there where both parents were too psychologically damaged, or substance abuse, or domestic violence, or child abuse. There were too many issues to have that child safe. And it's not ultimately my decision. It's the judge who would decide what to do. We would make that recommendation, though, in some cases.
Thanks, Ms. McGarren. Appreciate it.
Thank you.
Let's move ahead to Ms. Dawn Smith. Ms. Smith is from the Atlanta Volunteer Lawyers Foundation, and she's going to speak to us about the Guardian Ad Litem program. Thanks for coming, Ms. Smith.
Good morning, and thank you so much for having me. I am Dawn Smith, and I'm the Deputy Director of the Atlanta Volunteer Lawyers Foundation, which, among other things, runs a Guardian Ad Litem program for the Fulton County Family Court. In August of 1990, the Atlanta Volunteer Lawyers founded its program. It resulted from a judge in a domestic case feeling uncomfortable about deciding where children should live without knowing all the facts about those that were vying for custody. So he turned to AVLF, Atlanta Volunteer Lawyers, for help. Nearly 13 years later, we have placed about 1,500 cases. I think we're very close to that right now. And among other things, we received a grant from the American Bar Association to assist jurisdictions around the country in establishing their guardian ad litem program in the child custody arena. In Fulton County, in determining whether an appointment is appropriate, the court considers a lot of different factors. And I will start out by saying not every case has a guardian ad litem, and again, it's a very small percentage of those divorced or modification cases that are filed that have a guardian ad litem. Some of the factors that the court looks at is the desire that might be expressed by the child, any inappropriate adult influence or manipulation on the child that they're beginning to see throughout the process. And when I say throughout the process, what occurs is that the case is filed, and then you have a series of status conference where the parties, and if they're represented, their lawyers, meet with either the court, but more often a judicial officer who will begin to sort of walk them through the process. You know, where are we in discovery and filing financial affidavits? What are the issues around a temporary agreement about custody and payment right now? So you have these periodic status conference. So the court gets information on how are things going, where do things stand. Other factors the court might look at that's important is whether or not this is a case where a child might be called as a witness or may need to be questioned by the court in chambers, and the need to minimize harm to the child from the process. We're very limited in the extent to which, and rightfully so, I say, the extent to which a child may be a witness, is even considered competent to be a witness. And in the domestic relations arena, very conscious of the fact of the harm that it may cause, but even to talk to the court, much less to have to testify. The court may consider, and often this is a primary fact, the level of acrimony that indicates a lack of objectivity between the parents and their ability to see where to go and what might be in the best interest of the child. Other areas, any interference or threatened interference in custody or visitation, if there's any risk of abduction or allegations that mom's not letting dad see the child when he's supposed to see the child during this process. They're often appointed where the likelihood of a geographic relocation, the specter of that is present, and the court may need additional information about the child being limited in their ability then to see the parent or another sibling. And also where there are any questions regarding abuse, child sexual or physical violence against a child, domestic violence in the home, or any special physical, educational, or mental health needs of the child that may require additional investigation. We are lucky in Georgia, and actually a model for the country, that we have developed some uniform superior court rules that relate to the appointment of guardian ad litems in domestic cases, their conduct, their qualifications, and their duties. And I prepared this very quickly, so I don't have a copy, but I can email you each a copy of the Uniform Superior Court rule that we have in Georgia about how guardian ad litems operate. I will tell you that guardians are appointed to represent the best interests of the child. And lawyers and courts will split hairs about this, but it's very important. Guardians, in the situations I'm talking about, aren't necessarily there to represent the child, meaning I have to do what my client asks, I have to keep all his confidences confidential, and all those ethical obligations apply. In Georgia, our guardian ad litems in domestic cases are appointed to represent the best interest of the child, investigate and ascertain what are the facts regarding the child and the family situation, and then to, as an officer of the court, because we only have guardians who are attorneys in Georgia, to assist and provide that information to the judge. The guardian doesn't make a decision. The guardian does the investigation. So I'll tell you that some of the duties, and almost every guardian, these are the duties, when I say to investigate, to interview the parents, to interview and spend time with the child, to interview teachers frequently, to get all records, medical, educational, juvenile court records, social service records. They have a right to receive all those records and to review those. And any other any other investigative arena that the guardian feels may be helpful. The guardian may recommend to the court that they have the custody evaluation performed. So what I want to say is that in all the cases that Dr. McGarrett spoke about, probably most of those cases there was a guardian. But in all guardian cases, there's not a custody evaluation. It is only, and in fact, it's sort of an intermediate step that hopefully if you get the guardian involved in the investigative process, you don't necessarily have to have a custody evaluation. In fact, one of the guardian's specific duties is to assist in settlement and negotiation, and by being that intermediary who is an objective third party. They're not beholden to either side's attorney or either party, but to the court. Guardian ad litems now represent the best interest of children involved in disputes, not only between parents, but frequently we see between grandparents and parents, aunts, uncles, and every other conceivable and inconceivable family relationship. Many times the guardian may be the only person who actually speaks with the child because of that limitation I spoke about the court and testifying. As with all of our programs at Atlanta Volunteer Lawyers, we provide extensive training, and in fact, the Uniform Superior Court Rule details the type of training that a guardian has to go through. And it includes many areas. I'll just say just real briefly that the guardians are trained in the stages of child development, the impact of custody decisions. So all the research you just heard about is incorporated into the training as the research changes, as there are differing views about how to interpret that research. It's also incorporated into the training. They're trained, they have a substantial period where they're trained on the ethics of a guardian ad litem and what are their ethical obligations, domestic violence and its impact in custody determinations, as well as alcoholism and other substance abuse. We are a model throughout the state and have trained and been asked to train many other of the judicial arenas. We've trained in Chatham Hall, the 10th Circuit. We've trained the guardians there, and in Walton County on, now that we have the uniform rules, it's very helpful. Talking about the guardians and how to implement a program that works. Our volunteers accept, after they're trained, 1 to 2 cases a year, and I would just tell you generally that the order that goes out from the court anticipates that guardians will spend, that their first 25 hours will be pro bono. Meaning they will not be paid for that. And then anything over that, if the parties are able, may pay. But we frequently are guardians in cases where the parties are not able to pay, and we are Atlanta Volunteer Lawyers and provide pro bono services. So that's one way we've been able to handle the problem with the families and the many families that you spoke about that can't afford some of these services. I will tell you that there are some families that can very well afford the services, and in appropriate instances, the court will award guardian fees. The average guardian case is about 45 hours over 5 months. Some of them go into the hundreds of hours. Some of them, after maybe 5 hours, they're able to work with the families and get them settled. But there are a lot of folks that go above and beyond duty, and it can extend for months and months and months. The guardian is involved until the final decision regarding custody or visitation is determined by the court. That's sort of the length of their involvement. Does every case need a guardian ad litem? As I said before, no. But if I can just tell you the few that came across my desk last week, the ones that do, the rare ones that do need a guardian, 2 addicted parents and respective sets of grandparents who are all talking about what's in the best interest of the child, and everybody's got a different idea. Good people. Tragic situation. Need an objective person to go in and investigate and help the court understand what's going on. Judges don't do that. The alternative is, and I will just say my concern about not appointing a guardian until fitness is determined, is that what you have is that you have a judge, the only information that judge gets is information from the attorneys, whatever they decide to present in their advocate's way, and from paid experts. The guardian is an objective person, and to have to wait until that point to find an unfitness, which is a moving and very high bar, anyway, it really can only hurt the child. It's going to take extra time. We're going to only have biased information on both sides because good lawyers do their job, and no one objective in there from the get-go. The other couple cases I want to tell you about is the autistic child that I had come across my desk last week, who you've got parents that are so angry that neither of them are anticipating what the special needs of that autistic child are. How are they going to get him to a special school if they implement this custody arrangement? You know, who's going to pay for it? And then the family of where domestic violence is involved, and the alleged perpetrator wants to have shared parenting. And in that situation, yes, it's appropriate that a guardian is involved immediately and begin, even for the temporary basis, to determine what's good for the child. In a recent case, we had a clinically depressed 6-year-old who the family was able to work out things, and they presented the judge with an agreement that said, right now he's going to live with mom, but in a year we're going to split it 50-50 and he's going to go back and forth. That could be wonderful. No custody evaluation involved, but nobody thought about, he's clinically depressed. In a year, is he going to be able to do that? Or are we going to have a suicidal child on our hands? So guardian ad litem intervened and said, great, let's keep the agreement. Let's insert there that we're going to have a mental health evaluation at that time so that we can all feel comfortable that we're meeting Johnny's needs, the child with clinical depression, when we implement that shared custody arrangement. The cost of assuming fitness in every case and not allowing the court the discretion to investigate using a guardian ad litem, absent a finding of fitness, is great. The legal bar is hard. Without guardians in these cases, the court will only have the biased evidence, and the cost of failure to conduct an investigation would most certainly fall on the child, with a trickle-down effect on society. Divorce already exacts a high toll. We already know the levels of mental illness, suicide, and substance abuse. Children that we want to be productive services would not receive the protection during what we all agree is a traumatic time that they deserve and that they surely would need to grow to be productive citizens. A guardian's job is to cocoon the child and to help the court. Legislation that only appoints a guardian when there's a determination of unfitness, I assert, would not result in any different litigation tactics by the parties, but my concern is would increase it. We'd have a mini trial on fitness, and then we'd have maybe yet another trial on all the other domestic issues later.
I have to ask you to finish up.
But taking a protective layer away from the child, and it could hurt them. I'd be glad to provide you any information about the Guardian program, and I commend you for the efforts you've undertaken in looking at this issue.
Thank you, Ms. Smith. We have about 4 minutes for questions. Any questions?
Sorry.
Representative Earhart.
Thank you, Ms. Smith. I appreciate your testimony. I've been an advocate for the Guardian program for years. Actually passed the legislation on the liability shield.
Thank you.
A couple of years ago. So
Thank you.
I know and understand what good work you do. I wanted to ask you, you said that, one thing you said, and I think there may be a misperception, not necessarily in your case, that there is no legislation at this point, I don't think. Is there, Mr. Rice?
I'm sorry.
You don't have a...
No, we do not have a bill.
There is no
I'm sorry.
proposed statute. So you said that the cost of assuming fitness is great. I guess what I'm asking is, are you saying that the court should assume no fitness at all, or should take a position where they assume that one parent is fit up front, or no parent is fit? I guess, I mean, you got to have something. They can either assume no one's fit, or both fit.
My comments regarding fitness in that regard have to do with any proposal that a guardian not be appointed unless there's a finding of fitness. Okay. I think that in the best case scenario, we want to presume that all parents are fit. I think the nuances are innumerable. I think that what looks like a fit parent in a certain situation, when you get them in the acrimony of divorce and its aftermath, may or may not result in fitness. And I think the more objective eyes we have looking at it, the better off the child is going to be in the long run, really the parents.
So you're saying that, and I think I understand now, what you're saying is that a guardian can help to determine that fitness.
Oh, yes.
Give the court the information. So we're not assuming at all that one parent is fit, the other parent's not. So the original assumption, at least from what I've seen in shared parenting statutes, is that both parents are fit, and then obviously the court has the discretion to appoint the guardians for good reason.
Well, correct, and I think the starting point is that all things being equal, and if it works, we want the child to be with both parents, and everybody's a good parent, and if there's more investigation, let's do it.
Thank you.
One else quick follow-up.
Representative Manning.
Do you think that others other than lawyers could serve as guardians ad litem?
Do I think that they can? I think it depends on the level of training that they receive, and I think that there is a certain protection that is provided by being an officer of the court and by having standards that we have to adhere to in reporting to the court. Certainly, I think there's a situation where maybe if we have more uniform standards out there and ethical obligations, but right now I think we have the protection that's offered by both our state bar as well as by any uniform rules that makes me feel more comfortable.
To go forward a little bit with that, is it not true that the amount of money that the state provides for guardians is by far less than the hourly rate any attorney could cost?
Oh, yes.
Something like $65 an hour or something.
Well, the state doesn't provide, and I'm not sure what you're referring to. The state doesn't provide, our guardians, any money. But if the court orders that they be paid, on these cases, it's probably a third of what the lawyer could make anyway.
Thank you.
Representative Lindsay.
I think those situations you're referring to are those in juvenile court.
Right.
When there is a question as to the termination of parental rights. The court can, in those cases, appoint a guardian ad litem. I think the court will provide like $65 per hour fee for that.
Correct.
One thing I wanted to really, if you would really quickly, I know we're short on time, but one question came up from some of the panelists, and this is one reason why I asked you to come today. As far as the training, you alluded to the fact that all your guardian ad litems are trained. I thought it might be helpful to the commission if you just sort of explain what kind of training folks have to go through before they become a guardian.
Well, a typical training, and we'll have one in November, will be a full day training that they have to attend, and then we have to certify that they're even ready after that. And there we will have child psychologists who conduct a large portion of it, as well as folks from the State Bar talk about the ethics. We have professionals in domestic violence who come in and discuss in detail the domestic violence implications and the alcohol and substance abuse issues as well. And then what I didn't highlight is that we supervise all our guardians as well. I mean, we've been in existence with the Guardian program at least for 17 years, so we always have our hands on with them and in communication with the court so that nobody's running free and not able to have some assistance and backup and continue training.
Mr. Earhart.
Can I follow up on that training? Are your guardians trained on parental alienation syndrome?
Parental alienation syndrome, yes, I believe they are. I actually, I'm a new deputy director, but in the materials that I read, there were some extensive materials on parental alienation, and I believe that the child psychologists cover that.
Okay, thank you.
I mean, I can't imagine there not being training on that. So it's central to what we have to look at in this arena.
I'd be interested to know if they have. Can you
Mr.
tell us-
Lindsay, you have a comment on it?
That they do. For
I can get-
disclosure, I am a guardian ad litem. Of course, I'm also formally on the board of AVLF, and that is part of it. When the psychologists come in, that's one of the areas that they do discuss. is the
And I'll
concern
email
of
you that
parental
information
alienation.
because I know there's a segment that we have on it so that you can see
I'd
that.
like to see that too.
Okay.
Yeah, I think you're going to send that. I mean, if you could address that to Mr. Williams, that would be
Mr. Williams?
great.
Okay.
And he can get it out to everybody. That'd be fine.
Great.
And Keith, why don't we give them your email?
I have it. I
You
have
have
his
it?
email.
Okay. Well, all right. For anybody else who has some communication with the committee, we might want to give that out. Keith?
It's keith.williams@house.ga.gov.
Thank you so much.
Thank you
Mr.
so
Smith.
much.
Appreciate it for your coming today. Okay, we're going to take one more witness before we break, and that would be Robin Oppenheim, the National Association of Social Workers. Thank you for coming today, Ms. Oppenheim.
Good morning.
You're the only thing standing between us and a break, so, you know.
Oh, no. This is the worst place. I do have some brochures for you so that I don't have to go through, all
Thank
the
you.
details.
Appreciate you giving Mr. Williams. That'd be fine. Thank you for coming today.
Thank you. for listening. My name is Robin Reeves Oppenheim. These are reading glasses, so I don't have distance, so if I take them on and off. My company is Out of the Box Solutions. I've been in practice. I'm in private practice, and I'm also the North Georgia chair of the Georgia chapter of NASW. And I've been asked to come and talk about the ideas of shared parenting, and I was informed, that there was no specific legislation, but just to talk in general. So there's some information about who I am. I'm also a child of divorce, and I'm also a mother of 4 children, and so with personal and professional experience. Shared parenting, an easy concept to understand. 2 mature adults communicating, cooperating, and coordinating, working as a team to parent and make healthy, appropriate decisions in the best interest of their children. Sounds great. Why shouldn't we assume that this arrangement is best for all children involved in child custody situations? In a perfect world, with parents who are mature, who can communicate, who can cooperate, who can put aside their differences and work together as a team in the best interest of their children, it very well may be. But what about parents with alcohol or drugs clouding their judgment and guiding their actions? What about parents with either undiagnosed or untreated mental illness? What about parents who molest their children or allow others to molest their children? What about parents who bully, threaten, and intimidate? What about parents who hate each other and use their children as pawns to manipulate and hurt each other? How do we know? How do you tell? What do you do? These parents look like they don't meet the standard of unfitness. They look fine from the outside. How do we know that this is going on? The problem is that we really can't on the surface. With over half all of the marriages ending in divorce these days, that is a huge roll of the dice for some very defenseless and unsuspecting children. Let me tell you about Tony, who was referred to me by his probation officer. Tony's 16 years old. He's repeating the 9th grade. He was running away, smoking pot, can't sleep at night. He was deemed unruly or ungovernable. Let me tell you about Carol. She's 13, depressed, cutting herself with razors, referred by a teacher who found a suicide note. What do they both have in common? Parents who are divorced and in conflictual relationships. Children who are shuffled back and forth between very different parenting styles, discipline styles, households, who have no one to talk to, who have no one to trust, no one to tell, trying to figure out, struggling what their allegiance is and who their allegiance should be to. And most importantly, they have very angry and resentful, conflicting parents. Hang on. Children rely on the adults around them to protect and take care of them. And when that doesn't happen, who suffers? We all do eventually. And what happens when we assume? And for anybody who's been in a 12-step program, you all know what we say about assuming. Mm-hmm. We make I won't say it. Okay, so here we have a very, very multifaceted, complex issue, and a one-size-fits-all cookie-cutter approach just doesn't work. It takes a village. It takes all of the things that have so aptly been shared today. It takes the evaluation. It takes the guardian ad litem. It takes all of the people working together. The issues we've identified, the psychological, emotional issues, financial and economic issues, medical issues, educational issues, social issues, research that has been presented to this committee shows that all children exhibit symptoms of anxiety, depression, trauma, grief, and loss initially in a divorce situation. All children, to some extent, whether it's mild. But the research shows that over time, that the symptoms intensify, the symptoms are prolonged in families where there is conflict between the parents. So the need for a biopsychosocial evaluation, a complete evaluation, in cases where there's not agreement is essential to determine the individual needs of each family system. The courts need help to decide what the best outcome is. And, you know, if we think about adoption and what we need to do in terms of adoption, when we're looking at a family and whether it's a family, you know, for that child to go in, we do a home study. We have evaluations. We have people talking and looking and making sure that in the best interest of that child, that is the best placement for the child. When we have substance abuse issues that come before the courts, there's substance abuse evaluations and recommendations for treatment, for anger and violence. But we don't, and in some cases where, you know, it's very obvious that there's that level of conflict and that level of dysfunction, we have referrals and evaluations being done. But really, for the families that kind of fall between the cracks on that don't quite meet that criteria, we really need a way to look and see and to take individual considerations, not a one-size-fits-all, not a presumption that goes in either direction. And who are best to provide these evaluations? A variety of people, but particularly professionally trained, licensed people. Now, a lot of people ask me, I'm a licensed clinical social worker, and I get this all the time. Okay, what's the difference between a psychiatrist, a psychologist, a licensed clinical social worker? What is really the difference? You know, why should I use one or the other? And what I would like to say about that really is just a very basic thing, that where the psychiatrist is a medical doctor and is looking for medical illness, mental illness, you know, treats a lot with medication. The psychologist is trained to do the testing and looking at the brain function and the psychological functioning of the individual. Social workers are trained, all professionally trained social workers are trained in looking at the person within the context of their environment. We look at the individual, we look at the family system, we look at the school system, the social system, the legal system. We look at the dynamics, and we are very well trained to do biopsychosocial evaluations and make recommendations. So the value of having everybody that can be on the team to provide feedback for these families is essential.
Have about another minute there.
Okay.
Thank you.
In conclusion, let's see. I tend to be a little wordy, and I apologize, but in conclusion, the other thing I just wanted to share with you real quick is that Georgia NASW has a copy of this documentary, Out of the Shadow, and it's very interesting, and if y'all want to see it or have access to it, please let us know. It is a documentary by Susan Smiley, whose mother was an undiagnosed paranoid schizophrenic, and there was a divorce in the family. The father left, and the children were left with the mother, and she has done a whole documentary on the effect of her mother's disease on the children, on the family, everything. It's about a 67-minute documentary. And in those days, the presumption was that mothers should have the children. Okay, and this is very, very interesting if you all want to take a look at it. But in conclusion, would I like to see more fathers involved in their children's lives on a daily basis? Absolutely. Would I like to hear more stories of successful shared parenting? Of course I would. I think we all share a vision of better ways of parenting in divorce situations, of happier, more integrated and well-rounded familial care for our kids. Our challenge today is to find an educated, thoughtful, research-based ways to provide for and protect our most valuable assets, our children, while maintaining the integrity of each family system, honoring each family's uniqueness, and meeting the needs of each individual family.
Ms. Oppenheim, thank you. Other questions for Ms. Oppenheim? Ms. Oppenheim, just one question. Your services, how much, you've done this, obviously, performed these types of services. Just about how much would it cost a family?
I try very
do
hard to work within the context of the economics that the family has. For example, I'm a clinical social worker, and I do therapy and I do evaluations, and I am on most insurance panels. I take Medicaid, all of the Medicaids, all three of them. If people have, if I can perform services that are covered under their insurance, I'm also a provider for Cherokee County DFACS. I can invoice them directly. I try to utilize free resources in the community as well, and then, people can pay. So it depends on what the evaluation actually requires, how many hours and how many, but I really try to make it affordable and work within the context of each family. So it's really hard to say exactly. I think that in some cases it's an easy, not an easy, but it's less time involved. But in some cases, as has been shared before, it's very complicated, and you really do need to get a lot of people involved in the complete evaluation. And if I'm doing an evaluation, I need psychological testing, then I have psychologists that I refer to for that piece and bring it all together. Okay, thank you. Thank you for listening.
Thanks an awful lot. We appreciate it, Ms. Oppenheim. We're going to take a break, but the next on deck would be Kristen Rambo, Georgia Commission on Family Violence. So, okay. Will you ready yourself and come up there after we take a break? We're going to take about a 5-minute break, 6 minutes break. We will reconvene at 11:20. How's that sound?
murdered by their husbands or boyfriends in this country every single day. That's the national picture. In Georgia, we had 127 homicides due to domestic violence last year that we know of. Also last year in Georgia, there were well over 93,000 calls to domestic violence crisis lines. In 2003 in Georgia, there were almost 68,000 law enforcement reports of domestic violence incidents. Obviously, domestic violence is a big problem nationally and right here in Georgia. What does this have to do with the issue of shared parenting or joint custody? Well, rates of domestic violence that are already quite high, as we've seen, are much higher among divorce litigants than among the general population. As one of the previous speakers mentioned, the great majority of separating parents are able to develop a parenting plan for their kids without intervention by the courts. But there is that small percentage that we've talked about, between 10 and 20%, that require greater intervention by the courts. And unfortunately, within this group, the group that comes to court to resolve custody issues, domestic violence is a significant issue for the majority of these cases. There's one study, for example, that showed that domestic violence was present in 75% of these custody cases. It's been well established by countless studies that the most dangerous time for a victim of domestic violence is often when she leaves. Excuse me. In fact, attempting to leave a violent partner with children is one of the most significant factors associated with severe domestic violence and death. So divorce, particularly when it involves custody battles, is a highly lethal and dangerous time for victims of domestic violence. And if joint custody is granted, that highly lethal increased level of danger only continues. In one study, 25% of domestic violence victims reported that their lives were threatened while they exchanged the children with their batterer as part of a custody agreement. Now, some proponents of shared parenting say that there should just be an exemption for victims of domestic violence. And it would be great if that would work. Unfortunately, there's no exemption that would protect all or even most victims. As you can imagine, many victims of domestic violence are unwilling to state in court that they are victims for many reasons. Whether it's because of the social stigma that's still attached to being a victim of domestic violence, or because they rightly fear that this kind of disclosure will lead to further violence from the perpetrator. In other words, if she says in court, "He's abusing me," what happens to her when they leave the courthouse? Having to prove the domestic violence in court presents all kinds of further problems for victims, many of whom have avoided calling the police or even seeking medical attention for some of those same reasons, the stigma and the very real fear of additional violence. Last, there's a common misconception that women falsely allege domestic violence as a way to get a leg up in divorce or custody proceedings. In fact, studies have found that a finding of domestic violence in these proceedings actually works against the victim, leading to worse outcomes for them than for those who do not claim to be victims of domestic violence. A related misconception is that women are unfairly granted custody more often than men because of a judicial system that's biased toward women. In fact, women often do end up with custody when men leave and don't seek custody of the children. But studies have shown that when fathers contest custody, they're granted it between 63 and 70% of the time. Furthermore, batterers are more likely to apply for custody than nonviolent fathers, and their chances of succeeding are the same as those nonviolent fathers. We know that those who batter their intimate partners are more likely to physically and emotionally abuse their children. We also know that they routinely use the court system as a way to continue to try and control their partners, particularly at the time of separation. So given the high rates of domestic violence among divorce litigants in court, and the fact that no exemption could truly protect all victims from the increased exposure to risk that a presumption of joint custody brings, and the high rate of success among batterers who seek custody of their kids, the concept of shared parenting is a dangerous one, and not just in a handful of cases. And I guess that's what I'd really like to emphasize today. In far too many cases, a presumption of joint custody would place victims of domestic violence and their children in grave danger. So as you weigh the implications of this issue, I respectfully urge the committee to consider what it might mean for the many children and adult victims whom it would affect. Thank you.
Ms. Rambo, thank you for your testimony today. You mentioned in a number of cases, you referenced the word studies
Yes,
several
sir.
times.
Yes,
and
sir.
Obviously, we've heard testimony that kind of is contrary to that, and sorting that out is important. If you could supply us with the information
Yes.
and the references for your information, that would be good. If you get that to Mr. Williams, that would be
Yeah.
very good.
I'd be happy to. I've got all that, and I'd be more than happy to share that with the committee.
Questions of Ms. Rambo? Any questions from the committee? Mr. Butler?
You stated in your comments that you believe that a presumption of shared parenting is dangerous. I think everybody on this panel probably would agree, whether or not they agree with the concept of shared parenting as being presumed positioned by the courts, that if an exception was put in there, and I think that would be logical that would happen, that in cases where there is documented abuse, then obviously there wouldn't be a presumption of shared parenting. That's which there's kind of some of that already in code to a certain extent right now as it is.
Right.
I don't think anybody here on the panel would agree that shared parenting ought to be presumed no matter what.
Right.
But so let's say in the example where there's not cases of abuse or violence. Do you still think that shared parenting would not be a good concept?
I think the problem, I agree with you that an exemption is certainly necessary if there were to be such a presumption. I think the problem is that there are so many cases of domestic violence where it's not documented. And again, for a variety of reasons. I've worked with victims for many years, and there are all kinds of reasons why the abuse that happens at home does not end up on a piece of paper that lands in court. And it's those cases, and there are so many of them, that really concern me. Of course, those where it's documented should fall within that exemption and would escape that problem. But it's the many cases that don't end up getting documented that are a great concern for me.
Mr. Lindsay?
I'm just trying to get my hands on the fact that, custody hearings are basically a judicial proceeding. Someone has to show up, show proof of why they should be a better parent than the other parent. And I'm trying to get my arms around this idea that shared parent, which is broadly defined by the American Psychological Association, includes any split in parenting time of up to 30-70 split, with the parents dividing up legal custody with final decision-making power. Where that presumption, which let's just say simply is overcome by the best interest of the child, why that puts a greater risk to children than our present system, which really has nothing out there in terms of a framework for the courts to operate in, which means that it is an open field shooting gallery, in effect, when they go into court. I'm just trying to understand why that situation, as defined by the American Psychological Association, puts, if we were to presume that, puts a child in greater risk than what we have right now.
Right. Well, I think, if I'm not mistaken, current Georgia code does ask judges to consider joint custody. But I think the issue is that a presumption of joint custody would mean that there is, I think, then a presumption of fitness, and I think one parent.
That's one concept. I don't mean to cut it off.
Oh, that's okay.
Assuming that we have a presumption of shared custody within the definition of the American Psychological Association.
Okay.
Those studies, the Bowsman study, which is simply overcome by the best interest of the child standard. Why that would place a child in any greater risk than what we have right now, in which there is no framework for the judge to begin consideration.
I'm not sure if I'm understanding your question properly, but I think I think with that presumption, if it's up to, I don't know how that determination of the best interest of the child would be arrived at, but I think that if
Which is
the
what we have
presumption,
right now.
sorry?
Which is what we have right now with the best interest of the child scheme.
So if you add in then a presumption of shared parenting, it seems to me to overcome that, you would need to show that one parent is better or worse parent than the other. And again, I think if that burden of proof is on a victim of domestic violence, I just think it raises all kinds of problems that often she or he is not going to be able to overcome.
Well, don't we already have that right now? That's my question. I don't mean to be taking up all the time. Maybe I'm just trying to get my arms around it. We already have that right now. When you have to go to court, when both parents want the child, you got to put on evidence to show that you're the better parent to take care of the child. We already have that.
Mm-hmm.
Given that fact,
Excuse me.
how is the presumption that I sort of outlined going to change the dynamics that you're worried about?
I think I may not be understanding it well enough to answer, and I apologize for that.
That's fine. One other question.
Ms. Rambo, and that has to do with this. The 62% of the fathers who ask for custody get it.
Yes, sir.
I'm wondering about the statistics that I've seen, from HHR and from the census that indicate that it's a much, much lower percentage of that of fathers who do have any kind of custody. Can you comment on that?
Yes, sure. I think that the disparity there, the key point is about fathers who contest custody. So I think there are many, many cases for a variety of reasons where moms end up with custody
De facto.
Exactly, because dad's not seeking it or not contesting it. But these statistics just relate to when fathers contest custody. They are successful 63 to 70% of the
Could
time.
you just give me an example where that came from, what the study is, just on that one?
Oh, I don't have that.
That's okay.
It's in my little folder back at my
That's
seat,
okay.
and I can quickly grab it.
We're going
if you
to
like.
move ahead. If you could provide that
Absolutely.
information.
Yeah, I'd be
that would
happy
great.
to.
Mr. Butler.
What you were asking, I think what I'm curious about with that study, when it says that when the fathers ask for it, what's their baseline? Are they saying that if a father asks for custody, is that 60% the ones that get sole custody or that get a joint custody agreement? Or does it include both sole custody and joint custody agreements?
I believe it is sole custody, but I will go back and check just so I'm sure I'm answering you properly.
Thank you, Ms. Rambo. Appreciate it.
Thank you very much for your time.
Move ahead to Mr. Dick Bathrick, Men Stopping Violence. Oh, there he is. Okay. Thank you for coming, Mr. Bathrick. We appreciate your comments today. You have about 10 minutes.
Thank you, Chairman Rice, and thank you, committee members, for this opportunity. I speak to you as a co-founder of Men Stopping Violence, and we've been doing the work that we do to end violence against women for about 25 years, and in so doing, we do trainings locally, nationally, and internationally to work with communities to develop effective interventions with men who batter women. I'm also a licensed marriage and family therapist and have worked with couples and families and children probably for 30 years. And I believe I share with you the importance of really making sure that our children are safe. And I think I share with you the importance of children having access to both parents. But I also believe that when we introduce domestic violence into the equation, it really changes the lens under which we make considerations around shared parenting. And I'm going to give you information today that is not so much the statistics and the research, but more anecdotal based on the 25 years of sort of being in the room, working with men directly who have used power and control in relationships with their partners. Particularly, I'm going to speak a couple of times to what's the meaning of their relationships with their children and what are the effects of that battering. So first, just to take a look at how men who batter present to the public. My experience is that most of these guys are operating pretty normally out there in the world. You know, they may be doctors or lawyers or preachers, or they may be unemployed or unemployable. For the most part, they're operating normally, and as I say, sometimes successfully. They're likable. They're not punching out the boss or the cop on the corner. But when we talk about how they're operating in the home, they are using systematically incredible in controlling behaviors and tactics that include emotional, psychological, verbal, and sometimes, when those don't work, physical abuse. When they present to me, I notice a couple of significant patterns. And first, let me say that I notice that most of the men, when I see them and they describe the atrocities that they have committed, it's almost hard for me to believe it, because I almost never see the behaviors that they describe that they use at home. They're generally affable, reasonable to get along with. They seem to like me, and I find ways to connect with them and care for them without colluding with them. So it's something that I would want you to know, that when guys walk through the room, into the room, I don't sit there and go, well, there goes one, and that's not one over there, because that's not really how that works. I think another thing that I would want to share with you is that these men usually manifest a kind of narcissistic behavior, a kind of self-centeredness that plays out in a couple of ways. First, in terms of with their partners. They expect their partners to focus on their needs. And when those partners don't do that, they feel victimized and feel very justified in punishing the partner for not doing so. In terms of the children, there's little awareness of how his abuse of their mom affects the children. Let me give you an example. I will always ask a man, so when you made that choice and you were yelling those things at her, cursing her, putting her down, making those threats, how were your children affected? And so a man will typically say, well, they really weren't affected because they were in the next room. And so then it goes to sort of figuring out, so what are the immediate effects, what are the long-term effects? Don't you think that the ways that you treated her in that moment have lasting effects on her and therefore have powerful effects on your children? So what I want to say to you is that I would say easily 80% of the men that I interview will start off by minimizing, denying, and having sort of no clue about how they affect their children when they abuse their partners. And that is some of the work, that is some of the major work that they have to do with us, is to develop that kind of empathy and awareness of how they affect their children. But more disturbing than that to me has been a man's willingness to use the children to manipulate and control her. Men will, I think, even with some real sincerity, claim to me that they care about and love their children, and at the same time, they will report how they criticize, disrespect, undermine their partners to their children, in ways and efforts to gain and maintain control of her. And often they don't use physical violence against her because they don't have to. They know that she'll make concessions to him in order to protect her children. When she moves to protect herself and her children, he, in those moments, can feel threatened and even victimized, and those are moments when we are aware that he may be even more dangerous. An extreme example of this kind of narcissism is the man that you have heard about, have read about, who says, well, if I can't have her, nobody can have her. And then he goes, kills her, kills the children, and sometimes himself. A more common example that I experience in working with the men is, if I can't have her, if I can't control her, I will use the children to make a statement to her that she can't challenge, she can't threaten, she can't make those choices without my permission. And sometimes, and I say sometimes because a lot of times this happens after they've been with us and we hear about it when we're subpoenaed by the court or get reports, they will then begin to pursue custody. even though they know their children are in fear of what they might do to the mom or even to them. I think finally I want to say that I think these men are capable of learning to put their children's needs first. I've seen that happen. I know that they can care for them and demonstrate love for them, but it's not a linear process. Sometimes a man will go for a week, a month, several months, where he's clearly putting his children's needs first. And then in some kind of moment where he feels challenged or threatened, feels victimized, that's a moment when he can turn and retaliate. And that's a moment where he will feel very free to again resort to using the children to control her. That's a moment where, in my mind, narcissism trumps his caring and loving for his children. And he will use them to retaliate. So in that way, we think of this as a lifelong process. There are men that are in that process. And so if you're to ask me, so can I predict when, and how many times or how long the man will go, I can't predict that for you, because it's the man who knows that this is part of what he does and understands how he affects his children that has the best chance of putting their interests first, whether he's with the partner or not with the partner. I hope you'll take these observations into consideration when you consider shared parenting. And I also would want to invite you, our classes that we do with men are open to the community, because we would want you to see the work that they're doing and the work that we're doing. And for me to describe this to you, I suspect you would have your doubts as to how men would actually be willing to report the ways that they use controlling tactics. But I would invite you to be there to see that happening and see them struggling to make that change. I thank you.
Thank you, Mr. Bathrick. Any questions for Mr. Bathrick? I'm sorry.
I've just got
Ms.
one.
Manning?
What about the women? I mean, they can be mean, too.
Yes, women certainly can be mean and are abusive. What we're talking about, or what I'm talking about, is a campaign of tactics, very systematic tactics that a man will use to dominate and control. And those tactics, in some ways, are reinforced by a culture that does not hold the man accountable. And so I think when you talk about women's individual use of abuse, which is wrong, not acceptable, it's a different thing in the context of a culture that is so sometimes condoning even of men's use of force or threat of force in relationships. That's a major difference as I say it. It's not acceptable. It's just different and in a different context.
Thank you, Mr. Bathrick. Any more questions? Thank you so much for testifying today. We appreciate you taking your time to come down here.
Thank you.
Miss Julia Perella, who is a Georgia State professor. Ms. Perella, good to have you with us today. We're hurrying along here, so we appreciate your help. Thank you.
I appreciate the opportunity of being here this morning. I'm Dr. Julia Perilla. I'm an associate professor of psychology at Georgia State University and a licensed clinical psychologist. My areas of expertise as a researcher and practitioner are domestic violence, immigrant families, trauma, and mental health. For the past 17 years, I have worked and conducted research with families affected by domestic violence. I have written 2 book chapters and numerous articles on this issue. And for the past 12 years, I have co-facilitated a group for Latino men who batter that is part of a comprehensive intervention for Latino families affected by domestic violence. I serve as a consultant as well and supervisor for a similar group with other immigrant men and African American men. For 3 years, I served as a member of the advisory committee to the National Council of Juvenile and Family Court Judges Safe Havens Project. And this project was established by the Council to provide guidelines and oversee supervised visitation and safe exchange for children from families in which domestic violence was present. The Council did this because they knew of the danger to both survivors and children when these things were happening. This morning, I would like to offer 3 comments to the committee. The first is that the literature and my experience have convinced me of the heightened risk to survivors of domestic violence and their children in joint custody cases, given the dynamics of domestic violence that Dick Bathrick alluded to before, and the lack of appropriate mechanisms in our state to handle these situations. There are no safe places or ways in which, for example, supervised visitation can take place between children and fathers who have used violence against their mothers, and all too often the children themselves. The ongoing contact with a batterer that is necessary in order to comply with the necessary joint custody stipulations very often places survivors and their children in situations in which the risk for psychological abuse and even physical harm is a very likely possibility. The second point I would like to make stems from my direct experience with Latino batterers, although this experience is definitely not limited to immigrants, which supports that what the current literature indicates regarding the manner in which batterers often manipulate the legal system and the judicial system to their advantage in order to maintain control over their ex-partners. Let me give you an example, a man that I will call Pablo. He was divorced from a previous marriage and had 3 children. He had been given joint custody. He was referred to our program for a new situation of domestic violence with a new partner. When he was court-ordered and we told him about the issue of domestic violence, the reason why he was there, we asked him what the reason why he was there. He says, I don't understand why it happened this time when I had already been doing that before. And the judge thought that it was not so bad. He gave me the children. He said, he gave me the children for half of the time, meaning, of course, joint custody. The last point I want to make has to do with the children themselves. My research includes studies of child witnesses of domestic violence. And the households in which these children live often resembles a battleground in which they're unwilling as spectators and sometimes casualties. Children speak of their feelings as pawns, as their father's abuse and violence continues even after the divorce, most especially when they go from one house to the other. So I would like to end by asking that the committee looked at families affected by domestic violence as a category that needs careful consideration in divorce proceedings, so that the trauma already present in that family is not exacerbated by laws that may not take into consideration the specific realities of their everyday lives, and the awareness that in many cases the presence of domestic violence, as in Pablo's case, was not part of the record. Thank you.
Okay, thank you, Ms. Perrell. It's good to have you here with any other questions of Ms. Perrell. Thank you. I appreciate your testimony. I think, and I'll reiterate Mr. Butler's comments about none of the people on this panel have any interest in ensuring that there's an increased level of family violence and doing harm to children as a result of anything that we do here. And I think the issue is trying to reach that middle ground where both sides of the rights are protected adequately.
Absolutely, and like Mr. Bathrick said before, I also see the possibilities when the batterers are held accountable by the whole system, not just the batterer intervention program. So, thank you.
Thank you so much for coming today. Miss Shelley, I'm going to say it wrong, Centerfit? Centerfit? No.
Defer my time to go to the end for some of the folks who are down here all the time.
Sure, absolutely.
I just want to be sure the committee has time to hear from folks who take time out of their work days to come in.
Oh, okay.
Sorry. Dawn Elliard. Ms. Elliard's a parent testifying on behalf of parents, and we thank you for coming today, Ms. Elliard.
Well, this is very intimidating. I've never done this before.
Please don't be intimidated. There's nobody
Well,
up here
I don't know.
to be
Room full of
afraid
experts, and I had all this prepared testimony, and since a lot of it has already been covered, I think what I'll do is just share with you
Good.
sort of my personal experience.
You can give us your notes if you care.
Okay, thank you. My name's Dawn Ellard. I have been divorced for about 5.5 years. I am, it's funny when we talk about high conflict divorces, just hearing some of the testimony that high conflict being those divorces where you need to have, I guess, child custodians and whatnot. I would say I had a high conflict divorce but did not need to have any custodians. I was a victim of domestic violence in my marriage. Unfortunately, there were times when my daughter was present. I was fortunate enough, if you want to call it that, that I had the wherewithal, the fortitude, and the courage in which to actually press charges against my ex-husband, which therefore spared me, I think, and my daughter, the lengthy legal battle that probably would have ensued if there was a child custody case. Abusers are control freaks. They're bullies. I'm not here to bash my ex-husband. He's a wonderful father to his daughter, but at the end of the day, control freak and a bully. And even after I had him arrested, and after he sought, I guess, talked to 3 attorneys, he was still going to try to go for custody, whether it be joint physical or sole custody. Again, not being rational, going to do whatever he could take, whatever he could do to make sure that he was going to get custody. Thank goodness, because I had it documented, that was not the case. My concern is for those women who do not document cases of domestic violence, whether they are embarrassed, they don't have any family members for support, whatever their reasons. There are many women and men, there are men that are abused, but let's face it, the numbers are very small, that will not document. They're scared of what's going to happen to them. I mean, let's face it, the judicial system, the legal system for first-time offenders for abusive husbands is pretty lax. You get a slap on the hand. You may have to attend an anger management class. At the end of the day, they're let go, and they are able to spend time with their families. My ex-husband and I have an arrangement where we have joint legal custody. I have primary physical custody. He has the visitation, the standard every other weekend, 1 day during the week. I think a very generous holiday schedule, which we do follow. But like I said, it's been 5.5 years since our divorce, and there's still times when we cannot agree on things. There is conflict. It's just, to me, I guess what I'm struggling with too is this idea of shared parenting. How is that different from having joint legal custody? We have an arrangement where our child, our daughter, does get, I think, adequate time with one parent. She's just spared the problems or the trauma, I think, of having to go from one household, spending whether it's a week with daddy or a month with daddy, back to my house. There's the situations where, you know, the problems of differences in how one parents, the parenting style. I mean, there's a reason why people get divorced. I mean, they can't agree. And unfortunately, you do have those partners that cross the line and are abusive and again, will do whatever they have to do to get control of the situation. And again, it's just, for me, it's the people that do not take the time to document, that you don't have that in your favor when you walk into a courtroom. And unfortunately, many of them, and as a result, there's going to be a lot of families that are going to fall through the cracks, and you're going to have children that are just going to suffer. You really are. And also, when you think about shared parenting, I mean, I would think that one would have to live within close proximity of each other. Okay, my ex-husband lives in Gainesville, Georgia. I'm in Forsyth County. There have been times, actually, when our daughter was in the first grade, he decided to exercise his weekday visitation and have her spend Thursday nights at his place in Gainesville. Okay, an hour away from where her school district is. But he had the right. It's in the legal document. So guess what I have to do? I have to shell out $2,500 in a retainer for an attorney, take him back to court, which I didn't. I did not do that because, thank God, it didn't last very long because he was evicted from his apartment. But at the end of the day, he still did it because he was in his legal rights. It was there in the court document. I can have my Thursday weekday visitation. So our daughter has to get up at 5 o'clock in the morning so she can be at school by 7:25. I just think that you need to look at child custody cases on situations on a case-by-case basis. I mean, to have just blanket legislation that says, okay, we're going to have the presumption that joint custody is right in all separation and divorce cases is wrong. Not each divorce case is the same. Each one is unique. And I think that needs to be taken into consideration. And as a concerned parent, that's why I'm down here. And just so you know, I mean, I've been talking, once I heard about this, believe me, I'm talking about it at Starbucks. I'm talking to people on the street. I'm talking to other divorced men and women. And they were not aware of this pending legislation, but by God, they're paying attention now. because they are concerned. And there are divorced dads out there that think it's wrong. Why should you split a child's physical residence? Why? We have joint legal custody. You've got a great visitation schedule. Children can be involved with their fathers. They just do not have to physically reside in two different households. And that's my opinion.
Thank you. Questions of Ms. Elyard? Ms. Elyard, to set your mind at ease, there is no legislation that
I know.
is prospective legislation. Generally, the study committees reveal the results of the combined efforts of the people here and taking all comments into consideration, which will be yours. And so we thank you for coming today.
Let me ask one quick question.
Okay.
Sure.
All right.
Do you think that if a parent on either side does not have documentation that their case is somehow compromised when they get before the judicial system?
I do. I think, well, yeah, I do, because let's look at, the court system, you're so backlogged with cases. Are judges really, going to sit there and view this on a case-by-case basis? There's so many cases through it's sad. The divorce numbers are just on the rise. And I really do think that unless you've got the documentation, because how else do you find a parent unfit? The way my attorney explained it to me was to find a parent unfit, they basically have to be smoking crack cocaine in front of your kid or prostituting your child. Beating their mother, obviously, while the kid's in the household, doesn't make them unfit. Being verbally abusive in front of a child does not make them unfit. Do police officers come out and arrest an abuser because they're verbally cursing you out or being abusive in your household? I don't think so. I think that they will come out and make an arrest or you press charges because you have the evidence. You've got the bruise on your face. You've got the broken arm. That's the documentation, unfortunately, because verbal abuse and emotional abuse, they don't make arrests for that.
Thank you so much for coming. We appreciate your comments today. Okay, we're going to move ahead to Pam Gray, a family law custodial parent. I assume practitioner, family law, and a custodial parent.
Yes, that's exactly right. And I appreciate the opportunity to speak before the panel today. I am a family law practitioner and for about 8 years now in a domestic firm that represents high economic families. So a lot of the discussion that has been held today about a lot of family violence and those issues really don't impact my practice very much. What impacts my practice is a lot of money for a lot of fights. I also come before you as a single parent of an 11-year-old little girl who has been divorced for over 10 years and who has ran the gamut of different visitation schedules that have and have not worked over the span of 11 years. And I am here to say that what was appropriate for a 3-month-old child was not appropriate schedule for a 5-year-old. And what was appropriate for a 5-year-old was not appropriate when she entered into middle school. And to have a law that is a one-size-fits-all will not work. It simply will not work. And you've got to look at the particulars of the case, the particulars of the child. And does that take up court time? Yes. Does it take up resources? Yes. But what are we talking about? We're talking about our kids. And we need to get away, in my view, from what is fair to the parents and look at what is fair to the kids. I had a case recently where a very wise judge in a temporary arrangement, both parents wanted a joint physical. And you know what he said? He said, okay, on a temporary, that's exactly what you're going to get. You're going to get a joint physical arrangement. But guess what? The kids aren't moving back and forth. You are. And for about 8 months, the parents went back and forth. They packed their bags. They went and lived with friends or in a hotel or somewhere. And at the end of 8 months, guess what? They didn't want a joint physical anymore because it didn't work for them. It doesn't work for our kids either. let me step back from that comment for just a second. It works in some situations. When parents can communicate, when they live in close proximity, when they really can put the interests of their children above their hostilities for each other. And I'm here to tell you that that's not a common situation. It's just not, and that's our reality. You have to have, when they start going into middle school and start getting homework and projects that you learn about on a Monday that are due the next Monday, you got to have parents who will say, I'll meet with you every single Sunday night. And let's sit down and let's go over the plan for the kids and what needs to be done so we're on the same page scholastically, socially, emotionally. And if you have two parents that cannot do that, a joint physical is not going to work. It's not going to work. And who suffers? The ones that suffer are our kids. It may be fair to the parents because I get equal time, but it's not fair to the children. So I implore the panel that we have to continue looking at a case-by-case basis. We have to continue using our resources to look at the particular children involved, to look at the particular parents involved. I think one of the members said, what's the difference between having a presumption that may be overcome by a best interest of the children's standard? I think that what we need to do from a professional standpoint is really define what does best interest mean, more than a legal presumption of a joint arrangement. What does it mean? And I think this parenting plan, to force parents to sit down and really think about their lives and how they're going to adjust their lives to accommodate what they feel is in the best interest of their particular child is a fabulous idea. Make the mom, make the dad sit down and say, okay, what am I willing to do for a joint physical? If that's really what I think, am I willing to adjust my travel schedule? Am I willing to, if mom can't afford a house in the best school district that I reside in, am I willing to help mom buy a house so that we live in close proximity, or the other way around? Force the parents to sit down and think about their lives and what they are willing to do to accommodate the children, instead of just having a blanket presumption. I represent both men and women. I do feel there is a difference between a presumption for joint legal versus a presumption for a joint physical arrangement. And I do represent some fabulous, fabulous fathers who I do think feel in a divorce situation that all of their power, all of their control over their kids is taken away, because we presume that the mom should have final decision if she's the primary physical custodian. And I have found in my particular practice where I am trying to lead both parents is more to a joint decision-making process. And if parents can communicate and they can put their children's best interest above all else, I do believe you have to have a final decision maker. And I don't believe you should be delegating that responsibility outside these two parents. But I do believe that in the appropriate situations, both parents should participate in the legal decision-making for their children. And if that means you give one parent education and you give another one religion, or ever how you do it, to give both parents a feeling that they are participating in the children's lives, I think that would lead us far further to an idea or concept of fairness than a presumptive joint physical arrangement.
Well, thank you very much, Ms. Gray. We appreciate you coming down. Any questions for Ms. Gray? No, I'm sorry. Mr. Earhart.
Thank you, Mr. Ray. We appreciate your testimony.
Thank you.
We've heard, I think you bring a perspective that we haven't heard. The one concern I continue to have is the presumption that, with respect to any legislation, that it would be one-size-fits-all, I think, is one of the semantics I've heard, or that there is an automatic presumption that it's going to be a 50-50 split or something like that. Specifically, the shared parenting, Mr. Chairman, that I've seen, the statutory provisions in other states, not only do they go to the definition, and I think Representative Lindsay and many of us, we need a definition of best interest, more objective. Most states have
Yes, sir.
that. I guess the question, it's not as much a question, but just reading from an Oklahoma statute, I think what we're trying to get to, and what I'm hearing, is that beyond a presumption, there has to be a finding of fact. The burden of proof is on the litigants. The children are not in a position to advocate for themselves. That's why we have a system. But the burden of proof should be on the litigants to prove through the guardians, through the custody evaluators, why they should have sole custody here, and the judge should have to enumerate that. Not just, well, gee, that's what I thought. That's what you got.
I agree with that. I agree
That's what I've seen as shared parenting.
I agree that we need to put the burden on the person that makes the actual final decision, and that's our judges. What I have found, though, is that there is very few situations in my particular practice in which there is sole custody being awarded. When you come before that court and you show that you're a good parent and that you have good basis for making judgments and that you really are placing your children's interest above your own, I am finding that our judicial system, and maybe I'm very still new into this practice, 8 years into it, and I still have so much to learn. But I trust them, and I trust that they're making the right decisions based on the right factors. However, I do think that they need to put it on paper. I do think they need to say, in this particular situation, I find these two parents can't communicate. Therefore, I do not find that joint legal custody will work in this particular situation. And that is a finding of my fact, okay? I think that is critical. And I also think it's critical for the parents, because I think that once a judge says that, once a judge makes a finding of fact, then the parents should go back and be able to look at that and think about that and how can I change that because if I want to go back for the next go round, I better do something different. So I do think that we try. I know as a parent, I try to listen to what a judge says, and I may not always do the right thing. As a practitioner, I try to listen to what the judge says because I respect the judge's opinion, and I believe they I do believe they try very hard to look at the factors and come to what they find is in the best interest of the child. But I do agree that there should be findings of fact and conclusions of law.
Mr. Chairman, I appreciate that. Just a final statement. We have to legislate for the entire state of Georgia, and sometimes there are more professional jurists than others. There are still, we have to be able to anticipate through legislative authority all the situations, so all the people's rights and children's rights are protected. And as long as we still have certain jurists in Georgia who will state in open court the calf followed the heifer, then we have some issues. And
yes.
I think that's where we need to be concerned with.
Thank you so
Lindsay,
much.
you have a comment or a question?
A couple of quick questions, since you're in the field. Some issues that came up in the last session, I'd like your thoughts on. It goes along the lines of what Representative Earhart was concerned with, about your feeling about more appeals being taken by the appellate courts. Would that help provide some greater structure for the trial court and for the lawyers in terms of trying to figure out where exactly the law is in terms of who should be getting what kind of custody?
Well, I do think that we need some more law on it. I do think that it's just so nebulous that we all, as practitioners, I think a lot of us just do a rule of thumb. And, give me a 10-minute spiel of what your family's like, and I can pretty much tell you what the general outcome is going to be. I do think we need more guidelines, and I think we need more definitive ideas of what types of situations really lend itself to a sole custodial arrangement? What type, and that may be the family violence and those types of issues. What types of criteria lend it to a joint physical arrangement? You know, if you live within 10 miles of each other or whatever. Those are hard things to do, but if parents are willing to make those kind of accommodations to fit within the criteria that courts say this is likely to lend itself to a successful joint physical arrangement, then that would give us as practitioners more guidance in how to advise our clients.
If I may, to just sort of follow up with that, and this is an invitation that I've given to others and I give to you as well as anyone else who's testified. We've heard from a lot of folks who've asked for more guidelines and more guidance. That's what this study committee is all about, and my invitation to you is give us some ideas and give us some thoughts and put it down in concrete form so we can start taking a look at what type of additional structure would be beneficial to the courts in reaching best interests of the child. Yeah.
Let me ask just one quick one,
Okay, Ms. Manning?
if I might. You said your practice is primarily the affluent group.
Yes, ma'am.
Is there ever any consideration given to saying, okay, for each child, you pledge 10% of your gross salary to the education and nurture of that particular child on both parties? Is there ever any been a formula set down where people with means will quit fighting over, you know, the nickel I spend on a pair of shoes versus a child's orthodontia? And you just, I mean, you know, that's one part. And the second part was the illustration that you gave about the two parents who had to pack their suitcases back and forth. What happened at the end?
They did a more standard visitation schedule
But the children started moving back and forth.
on a more of an every other weekend type basis. You cannot keep the children in the same household on a permanent basis. Generally, that won't work unless the parents, at the end of the litigation, agree to that, because there's an equitable division of property, and the courts aren't going to generally say we're going to maintain that household till the lowest, the youngest reaches the age of majority. So decisions will have to ultimately be made in that respect. With respect to the money issue, in the affluent arena, I can assure you there's just as many fights, and they can nickel and dime it just as well as people who have a $15,000 to $20,000 annual income. It can also be used as weapons, and I am fearful that a presumptive joint physical arrangement would lead to greater litigation in my particular practice than to less litigation, because I think it can be used as a pawn up until the very day that you try your case, at which time you may give in. But
even if you have a formula?
Well, I'm not sure. I apologize. I'm not sure I quite understand about the formula. We have certainly situations in which people just establish a trust, which is fully funded, which can meet every potential need of a child through their minority. But I can tell you, litigation then occurs with the trust issues. I do believe that parents need to share economically for the care of their children, just as I feel that parents that have proven themselves should share in the raising of their children. But to put a formula on it, you generally don't find that in settlement negotiations, especially with a mom who has been a stay-at-home mom. They can't do it.
Well, I had a letter from a lady that asked for, she said her husband made $150 and she made $40, and her suggestion was, let him pay 10% of his salary, I'll pay 10% of my salary for each child in the home. And that was, to bring the money question and put that off the table and let the other issues be handled by the court.
Ms. Fairwood, we're going to have to move on.
Thank you so much for your time. Thank you.
Where we are right now, we've got 4 people, and I've got about 28 minutes left here.
Thanks for the time. I'll be as brief as I can. My name's Nancy Grigsby. I'm the Executive Director of the Georgia Coalition Against Domestic Violence. I've been working in the field of family violence for 26 years, and I've been qualified as an expert witness in many cases in the state of Georgia. I want to just limit my comments to a couple of areas that I think haven't been really addressed. I will provide the committee the substantial research that does show that custody disputes are disproportionately family violence cases. The APA has found that, a number of researchers have found that, and I'll provide that to you. There is also ample research about the percentage of cases where, when there is contested custody, a domestic violence offender will prevail, and those numbers range between, there's a study that says 40 to 70%, 70 to 90%, 82%, 79%, but they are all clearly on the side of the majority. So when domestic violence offenders do seek custody, which is rare, they tend to prevail, and that research is well documented, and I'll be sure and get that to you. I want to talk about two things real quickly, and that's about children, so that we're real clear about the stakes involved in placing a child who has witnessed domestic violence in a shared parenting arrangement. Just want to talk briefly about them, and I want to offer you some information also about this documentation problem that I've heard you struggle with this morning, so I will be brief. I know that you appreciate that the stakes are high with all children. I just really want you to appreciate the data that is just pretty much so repetitive and ample that I feel real confident that these are facts. Children exposed to domestic violence, not all of them, these effects are not universal, but they seem to affect almost half of child witnesses. We're talking about aggressive behavior, diagnosable anxiety, diagnosable depression. That data has been repetitively established. When we look at these kids as they go into the juvenile period of their life, their rates of delinquency are staggering. We're talking about higher rates of sexual assault. We're talking about 40% of the children in this country in the juvenile court system being children who witnessed domestic violence. We're talking about much higher rates of alcohol and drug abuse, and much higher rates of child prostitution, much higher rates of running away, and tragically much higher rates of suicide, both attempts and completions. So the stakes are very high for all of us, and I know you appreciate that, but I wanted to just emphasize that. When we are talking about these kids, we've got to be sure that we are not putting them in harm's way when we can figure out the difference. There's also some studies, I'll save that and send it to you all, on the level of physical and sexual abuse in these families. It is disproportionately higher than it is in the general population. So we are talking about children who are traumatized by witnessing, but also are more likely than other children to also be the targets of physical and sexual abuse in these families. So I think we'd all like to believe that we can easily exclude these cases. And I'd love to draft some ideas for you all on how to do that, but I got to tell you that every time I sit down to write that out, I can't quite figure it out. And here's the dilemma that we have. First of all, there's suspicion. When you raise family abuse and child abuse and sexual abuse issues in a divorce setting, there's automatic suspicion about false allegations. We all know that. There should be. We don't want people misusing the family violence statute in the state of Georgia. The problem we have, as has been alluded to by other speakers, is that this is, you don't get a red star for being a battered woman. People don't come forward and want to identify themselves this way. The FBI has, and I'll provide these studies to you, the Department of Justice has said that half of the offenses are never reported to the police. Other studies say that only 1 out of 40 women even go to a shelter or call a hotline. In the state of Georgia, we're fortunate in that we study fatalities. We have federal funding to study when people die. We need to do that because we're in the top 10 in the country in our rate of domestic violence homicide in this state. And when we study women and some men who were murdered by their intimate partners, and we look at and read the times that they called the police before they were murdered, we find that in less than half the cases were their prior injuries at the time they called the police. When you read those offense reports, sometimes they look like pushing and shoving and throwing dishes. And yet later, these women were brutally murdered at their workplaces, on the sidewalk, in the living room, some of them in front of their kids, some of them with their children. So the dilemma that I think we all have here is that we've got a bad paper trail. When we talk about creating an exemption, we talk about then saying, claim you're a battered woman, prove you're a battered woman. But what the Department of Justice shows us, what our studies of dead women's lives show us, is that battered women do not come forward in ways that they can later prove. Even when we looked at women who had called the police prior to their death, we found that most of those cases were never prosecuted. So we've got a dilemma here in that we want to believe we can exclude cases where people have been seriously injured or are in dangerous situations, and yet the data tells us that job is much harder than we'd like to believe. I want to just address real quickly one other issue, and then I'll wrap up. The organization that I direct succeeded in getting a $650,000 grant from the Department of Justice to provide fees for legal representation for people who cannot afford an attorney. And we have that funding for another year and a half, and I don't expect that we will continue to get that. And it is only because of that that in most counties in the state of Georgia, economically disadvantaged people can even litigate their divorces, period. But we don't have funding, and we rarely succeed in getting the kinds of skilled psychological testing and evaluation that the court is going to need to understand what the impact is on children, whether or not the claims of abuse are in fact real, and how we can somehow establish that in the absence of a TPO or a police report or a prosecution. So again, I loved hearing about GALs and psychological evaluations, and I'm here to tell you they are not a reality for many of the women that seek assistance through the Georgia Coalition. I'm going to end by telling you about a woman I worked with when I was an advocate who was married to a doctor, and he beat her through her whole marriage in front of their 2 sons. And she never called the police. She lived in a $1 million house in a very nice neighborhood. She never went to the emergency room. He would take her over to his practice at night after it was closed, and he would stitch her up himself. There was no record of the abuse that woman suffered. And so when she finally left him, she went and got a protection order. And she made her allegations of abuse during her divorce. And she lost custody of both of those children, and she ended up living in subsidized housing. She spent every dime she had trying to litigate that case, and she lost. She scored badly on the standardized tests they used. They had a psych evaluator who knew nothing about family violence, and she did not present well in the court, even though I worked with her for years. I found her to be quite sane and a good, concerned mother. Now, eventually, that relationship was restored when her boys became of age, old enough that they could spend time with her voluntarily. But if we're hoping that we can exclude these cases, rich and poor, there are going to be many, many, many that do not come to the level of evidence that I think courts would ask for in order to create the exclusion. And that is the dilemma that we face. And I don't envy your job, and I appreciate you listening to me. Thank you.
Thank you very much for the testimony.
Sure.
I understand the dilemma you're talking about. I want to focus in on a couple of facts that
Sure.
you offered. I'm looking forward to your submitting. I think I heard you say that over 60 to 70% of those who, did you say convicted offenders or alleged offenders of domestic violence who ask for custody actually get the children?
People who the court, well, I'll read the studies. I imagine the standard is different in each of those studies.
I guess it's the distinction I'm asking for.
Right.
Is it a convict?
It's
What
not.
I'm finding hard to believe is that the judges in Georgia are granting custody to convicted offenders. And I guess where I'm going with that is, how do you change the standard? How is that not a unreachable standard for an innocent person? How is it not a guilty until proven innocent standard, which even, the crassest murderer in our society is granted? It may not be convenient. Maybe we would like to.
Right.
But it is our standard. And I don't know that there's a better standard in this world than that innocent until proven guilty.
Absolutely.
So I think this is the dilemma you're talking about. But how can we change our basic standards in this country because of the ends justify the means type of argument is where we're going, I think. So are you saying that the judges are granting convicted domestic offenders custody 70% of the time? I'd find that.
No, that's not what I'm claiming. I'm claiming that there are a series of studies. I found 6 or 7. A couple of them I already knew about. I found more where, and most of the studies will say where there's a finding of domestic violence, which clearly could have been a finding within the facts of the divorce, a prior TPO. I doubt very often a conviction because this crime is not generally prosecuted. So we're talking about probably a whole range of evidence where there was a history of family violence that the court found, but then still made an order of custody to the father.
I'd like to see that.
I'll
I can't
offer it to
imagine
you.
a judge who would give someone who actually is, I mean, a TPO can be given upon an allegation.
Right.
And then you do have due process. You are entitled in this country
Right.
to the ability to defend yourself against that allegation. We heard testimony last week specifically to a great deal of false allegations. So, I mean, anecdotally, we can shout past each other. I'd like to get to the facts and see where we are with that.
Right. I'll offer you, there's also extensive research on the whole concept of false allegations, which I think is in the mind of the court more often than it actually really happens.
Actually, I've seen a continuing education seminar for a legal profession that said how to use the TPO as leverage in a divorce action. I mean, obviously, there's some validity to that.
And I believe those attorneys should be held accountable. We don't like them doing it either.
Mr. Lindsay.
Just a quick comment. What I take away, Ms. Grigsby, I'm sorry, from your testimony as well as Ms. Rambo, if she's still here, is that our present system is not working. Obviously, the fact-finding methods that we are presently using in order to determine the truth by a judge aren't working. And so what I implore you to do is to go back and talk to your group and talk to the experts that you work with and come back to us with some specific recommendations on how within the process that we have in terms of fact-finding, whether we have a presumption of shared custody or our present system, it's not working in order to find the facts as you found them. Show us how we can help the courts find those facts correctly so that we don't have the statistics that you've been alluding to. And I ask you to get back to us with specifics.
I've got some ideas. Thank you.
Thank you for sharing that.
Get organized here. We have obviously very limited time. Ms. Centerford, do you want to comment right now? You want to come back on the 26th? That's great. You are a hero today. We'll give you the official badge. Mr. Kessler.
Mr. Chairman, he had a hearing in court, was going to get over here because I don't see him here, so.
Aha. Okay. Boy, you are a double hero today.
Just trying to be helpful.
Okay. Mr. Holmes. Mr. Holmes, you said you may or may not want to testify today.
I may or may not even be legal to testify. But I'll explain that. Because I guess what I meant by that, I was talking.
Why don't you give your name and
Yes,
so
sir.
that everybody's got a little bit.
My name is Jim Holmes, Mr. Chairman. I've been practicing law since 1978.
You'll stand by the microphone. That'd be great. I know the courtroom.
You're taking that away from me. Yes, sir. At all times since 1978, I practiced within the family law arena. I've been an attorney in custody cases on both sides. I've been serving as a guardian ad litem since 1985 and have been a mediator in these cases since 1994. I thank Mr. Everhart for the legislation protecting the guardians. As I'm sure he well knows, a Cobb County constituent was one of the people that got into some legal problems. Yes, sir. And I thank you all for having this hearing. I was talking to Mr. LaCroix, who I think favors the presumption, and he looked at me and said, "Certainly, Jim, you're not against shared parenting." And my answer is no. But my response was further, I'm against any presumption for shared parenting, and quite candidly, Your Honor, Mr. Chairman, I'm against any presumption either way. I would be against a presumption that says every other weekend and 2 weeks in the summer are enough. In response to a comment you made, Mr. Everhart, remember that when you make a presumption, it changes the dynamics of the litigants. It changes the evidence. It changes the way you have to present your case and who you use to present your case. So anytime you use the word presumption to us lawyers, it's changing the leverage within the courtroom dramatically. Also, Mr. Lindsay, appeals are wonderful. Damn, they're costly. You've got a lot of people that can't afford to take the appeals. I question whether you have a de novo appeal or are you going to be sitting in judgment of the discretion of the trial judge that got to watch the dynamics of the witnesses and the professionals that testify. Yes, we do need guidance, but I don't know how you do that with people sitting behind a bench that didn't get the sense of what really went on in the courtroom. I would ask that if y'all do anything in the form of a presumption, you state it in the concept of what you presume to be in the best interest of the child. I'm going to suggest to you that if you take the eye off the gold and term it in anywhere close to fitness, you're missing your mark. In my practice, I have found far more often than not that the concept of best interest and the concept of fitness are mutually exclusive terms. When doing a guardian work, I have never had or gone into it with the idea that either parent is unfit. And I think there's really a presumption out there that the parents are fit. In fact, in juvenile court, if you want to terminate a parent's right, you have to prove the unfitness. So I think that presumption is there. But I think if you put in the law a statutory presumption, you've, one, missed the goal that we're here to talk about today. And I also ask, are you causing yourself problems in the juvenile court setting, in the deprivation proceedings, or in the termination proceedings? I don't know. I'm not smart enough to know that. I don't do juvenile court work, but I just raised that issue. The concerns I have about the shared custody, in my experience, is that it works only if the parents agree to make it work. I have found 3 general necessities, if you will, that I go into with a gut check on shared custody, and they're certainly not written in any psychological study. One is there's got to be geographical proximity. If the parents aren't living close to each other, if they're not living in the school district, if they can't get to and from each other, the kids are spending a lot of times in car seats, and that's not good. Secondly, I believe there needs to be some sense of a similar philosophy between these divorcing parents as to how they're going to raise their children. Now, yes, there are going to be different rules at different houses. I didn't tell you I was a divorced father. I was not a custody father. I sat down with my daughter, and there's a great book called Dinosaurs Divorce. If you never read it, get it. And it talks about different rules in families. But you've still got to have parents that got the same gut check on how we're going to raise the kid. The 3 C's were thrown out at you earlier today: communicate, coordinate, and cooperate. Thank you. There's so many parents that try to talk about sharing custody, and they can't even talk to each other. There are more and more custody cases going down now where the stipulated way to communicate is email or text messaging. That's a hell of a way to try to arrange shared custody. Finally, the third thing I would tell you is I think there needs to be in shared custody some sense of economic parity. Otherwise, you're going to have a playhouse and a house that we're just getting by on. And the kids will, I will tell you, gravitate to that. Mr. Lindsay, you talked about the 37%, and I did not hear Dr. McGarrett's testimony. You say that comes from the American Psychological Association. That may be it. I mean, maybe if you do every other weekend and some time in the summer, I don't know, maybe you're there. I'm concerned about stating any percentage. One, what is a percentage of what? I know even when y'all were doing the parenting time adjustment, we had difficulty of how we define a day. Then if you get to 37%, well, let's up it to 40. Let's up it to 42, and then all of a sudden we're up to 50. So I have concerns about that. But my major point on that is I don't think there ought to be any presumption that is designed in any way to address the parents. The presumption needs to apply to the best interest of the children, and any presumption y'all make, please understand, it doesn't change the fact that we're going to have contested custody cases. It simply changes the dynamics of the courtroom. And I'm going to suggest if you go too far, the presumption becomes economic leverage in custody cases, whereby the parent who is truly acting for the best interest of the child gives up economic benefits just so that they don't have to face the presumption established by the legislature as to how much time the child has got to spend with the other parent. And that's all I've got to say. Thank you all very much.
Thank you, Mr. Holmes. We appreciate it. Stand for questions. Are there questions? Mr. Holmes. Did you offer?
No, but the same invitation as we wrote from the other, that specific.
Yes, sir. Thank you.
Well, thank you so much. I appreciate the fact that many people have come forward to testify today, and I think the testimony's been very, very good, as a matter of fact. I would hope that, as we've said before, that you will submit information that provides veracity tests to the documentation that you've mentioned, and get that to Mr. Williams. I understand that the proceedings of the prior meeting were on the web. In fact, I understand they were on the web while this meeting started to convene. So you'll be able to go back and look at that, as we will be able to do this meeting. I know we probably got to a couple of people who signed up late and didn't have a chance today. You will have a chance on October 26th. All you need to do is to contact Mr. Williams, and we will put you on the calendar for that particular day. Any other comments or questions from the panel? Well, we really sincerely appreciate you all taking time out of your busy schedules to come here today. Thank you. We're adjourned.